Today I'm going to talk about a $260,000 settlement for an Uber driver who was injured in a car accident in Miami. I'm going to talk about how we were able to settle the case for $260,000 and put as much money in my client's pocket as possible. I'm going to explain why this case settled for $260,000 even though the Uber driver did not have surgery. JZ Helps of Florida Injury Law Firm. I'm attorney Justin Ziegler. My client Ray, an Uber driver, was headed straight in Miami, Florida, when another vehicle made a left-hand turn. It was coming in the opposite direction and they crashed. The other vehicle is listed as vehicle number 1 on this diagram. My client is listed as vehicle 2. There was a decent amount of damage to the at-fault driver's vehicle. He was driving a commercial van. The Uber driver's car had a good amount of damage to his vehicle. The police report said that the Uber driver had no injuries. A couple hours after the accident, we received a call from the Uber driver. He wanted to know what his rights were. The first thing we said is, if you are in pain, you should go to the hospital. He went to the hospital a few hours after the accident, and that resulted in a 6-day hospital stay. Insurance companies often put a lot of weight on the damage to the vehicle when deciding how much to make an offer to settle a case. In this case, my client, the Uber driver's vehicle, was badly damaged, thus that related to a higher settlement. Also, had he taken an ambulance to the hospital, that would have resulted in likely a higher settlement because his total medical bills would have been higher, his out-of-pocket medical bills would have been higher, and juries tend to award more money for people who take an ambulance to the hospital. They believe that they are more badly injured than if you wait a few hours. The best news for my client in this claim was the at-fault driver was driving a commercial van, meaning he was driving for his employer, and they were insured by American Casualty Company of Reading, Pennsylvania, also known as CNA. Now, they had a $1 million insurance liability policy for this claim. So my client was very, very fortunate. Most accidents, the other driver has $10,000 of bodily injury insurance. My client was very lucky that there was enough insurance to pay for his injury. As you'll see in a little bit, CNA also pays above average for personal injury cases. CNA pays better than State Farm, Geico, Allstate, Progressive, and many other insurance companies. That is, they have a reputation for paying more money for the pain and suffering component of a claim. Now, this is a photo of the Uber driver at the hospital. I actually visited him at the hospital a few days after the crash. Like I said, he was there for about 6 days inpatient, which is not the norm for most accidents, but I took this photo, and I'm happy that I did take it because it shows an oxygen tube in his nose, IV lines into his arm, and it shows that he was badly injured. This photo was very effective in getting the case settled for $260,000. I constantly sent this photo during the negotiation, which I'll get into in a moment, to the adjuster, the insurance adjuster for CNA, whenever she would try to minimize how badly my client was hurt. The CAT scan showed that my client had a fractured lamina in his spine. Now, this photo shows where the lamina is, and all things equal, a fractured lamina is not worth as much as if the vertebrae itself was fractured, also known as a compression fracture. This is a top-down view showing what the lamina is, and the T3 is the fracture that he had. The fracture was in his thoracic spine, which is right above the lower back. Now, the T3 is on the upper back. This image shows you where the T3 is on the upper back. There was minimal displacement with the T3 lamina fracture. The more displacement, the higher the value of the case. Minimal displacement means that the fracture was well aligned. So if the fracture moves a lot, that would be major displacement. If it's just a little bit, that would be minor displacement. The Uber driver, Ray, also had an MRI of his thoracic area at the hospital. The MRI did not show the lamina fracture. Now, sometimes CAT scans are better at visualizing bones than an MRI, but also the MRI did not show edema, which is swelling. Typically, if you have what's called an acute fracture of the spine, which means it was caused by the accident and recent, there's going to be edema. Edema is swelling caused by excess fluid in the body's tissues. If you have an acute fracture, there is typically going to be edema that is visible on the MRI. And this is one of the things that the insurance adjuster for CNA Insurance Company argued when we were discussing how much my case is worth and when we were negotiating. She had mentioned to me there was no edema. She also mentioned that the MRI did not show the fracture, but she did admit that the CAT scan did show the fracture. So those were issues in terms of how much the case was worth. The Uber driver also had an L4, L5 disc protrusion and an L5S1 disc protrusion. Now, nowhere did it say herniated disc in the hospital records. However, we argued that those were herniated discs, and typically insurance companies will argue that a disc protrusion is a bulging disc, trying to pay less for it. Ultimately, what matters is when a radiologist reads the MRI and he measures how big the protrusion is, and that will determine whether it's a herniated disc or a bulging disc. Both of the disc protrusions were pressing on the thecal sac, and one of them was possibly pressing against the nerve root, which one can cause pain radiating down the leg. Now, the Uber driver spent 6 days in the hospital. All things equal, the more time that someone spends in the hospital as a result of an injury where someone else is at fault, the higher the value of the case. He ended up, as you'll see in a moment, with a $99,000 total bill charges from the hospital. Had he spent 1 or 2 days in the hospital, that total charge would have been a lot less, and the settlement would have been a lot less. When it came to paying out the personal injury settlement, CNA was generous. However, my client, the Uber driver, was driving someone else's car. It was not a relative of his, but he was driving someone's car, and it really took a long time for CNA to authorize getting his car fixed. The Uber driver did not have insurance on the car he was driving. The owner of the car did not have insurance on the car that he was driving. The Uber driver wanted to go through CNA's insurance company, the other driver's insurance company, to get his car fixed. CNA took a really long time. It was about 45 days or so, and they insisted on taking my client's recorded statement, the Uber driver's recorded statement, and I said no. Typically, I do not give a recorded statement to the other insurance company, nor do I even give a statement at all to the at-fault driver's insurance company. So I filed a consumer complaint with the Florida Department of Insurance, and upon receipt of that, shortly thereafter, CNA paid to have the Uber driver's car fixed. After the Uber driver was released from the hospital, he ended up seeing a neurosurgeon who was on my client's Medicaid plan. The neurosurgeon looked at the CAT scan from the hospital, and he did agree that there was a fracture of the T3 lamina. However, he said he could not tell if it was acute. That means the neurosurgeon could not tell if that fracture was related to the accident. The neurosurgeon did say it appears that the Uber driver had suffered some trauma from the accident, meaning he was injured from the accident. But all things equal, when the neurosurgeon says, or orthopedic surgeon says, that the fracture or other injury is acute, meaning related to the accident, that helps the case have a higher value. If the treating doctor does not relate the fracture to the accident, that can cause problems. However, in Florida, you're entitled to recover for an aggravation of a pre-existing injury. So even if Ray had had this fracture prior to the incident in Florida, if a jury can't determine how much of the fracture was caused by the crash, in Florida they have to award the entire value for pain and suffering related to the incident. Now, we settled this case before filing a lawsuit, but had we filed a lawsuit, CNA would have the right to hire a neurosurgeon who likely would look at the CAT scan and say that the fracture was old, there was no edema or swelling, and that it existed before the accident. The neurosurgeon said that the Uber driver had degenerative changes to his lumbar spine, his lower back. In other words, the neurosurgeon was saying that Ray's spine had already begun to deteriorate, which is common. As we get older, the spine starts to break down. The neurosurgeon did not recommend surgery, and he recommended physical therapy, so Ray treated for 2 to 3 months of physical therapy. The neurosurgeon recommended that Ray see a pain management doctor. However, Ray had Molina Medicaid, and it was very tough. It was impossible for him to get a referral to the pain management doctor after trying time after time to get his primary care physician to give him a referral. We finally stepped in and referred him to a pain management doctor who performed an epidural injection to his lower back. Now, this is an image of him lying face down after the epidural injection. The practice that had the pain management doctor agreed to wait on getting paid until we settled the case. The Uber driver was engaged in a ride. He had a passenger at the time of the crash. At the time of this crash, Ubers in Florida were insured by James River Insurance Company. Now, when an Uber driver is engaged in a ride, either has a passenger or has accepted a ride, there is no PIP insurance through Uber's insurer. We sent a letter to James River, and they sent us a letter saying there's no PIP coverage. Now, if a crash happened today, Progressive is Uber's insurer, and they would respond with the same letter saying that there's no PIP when the Uber driver is engaged in a ride. The positive is that the Uber driver then does not need a permanent injury in order to make a claim for pain and suffering against the at-fault party. The negative is that there will be no PIP insurance likely to pay the hospital bill or other medical bills or lost wages. The Uber driver had a $99,000 hospital bill. The Uber driver had Molina Medicaid. They initially paid the hospital on the $99,000 bill. They paid him $2,900, and the hospital had to write off the balance, meaning the Uber driver would have owed the hospital zero, which this would have been great for the Uber driver. However, Molina Medicaid, after reviewing the bill, ended up taking the money back because they said that because this was a car accident, Medicaid should only be the payer of last resort, and they believed that there was other insurance available. We got involved for my client and filed an appeal with Molina Medicaid and said, look, there's no PIP insurance either on the Uber, and my client didn't own the car, and the owner of the car did not have PIP insurance. And although CNA, the at-fault driver's insurance company, had an insurance policy, there's no insurance that should be primary to Molina Medicaid. Molina Medicaid disagreed. We filed a complaint with the ACHA, essentially the body that regulates Medicaid in Florida. They reached out to Molina. We ended up speaking with Molina's attorney as well. And finally, Medicaid agreed to pay his hospital bill. So Medicaid ended up paying $2,900. The hospital, by law, should have to write that balance off, so the client should owe zero, and that takes a $99,000 hospital bill or so down to zero. My client does have to pay Medicaid back based on Florida's subrogation laws as they relate to Medicaid. However, that puts a tremendous amount of money in my client's pocket. Now, we've reached out to the hospital and they say that the client owes somewhere around $6,000 and they're reviewing the bill to make sure there's no other insurance. Now, we prepared affidavits to the owner of the car and to my client, both of them attesting that there was no insurance on the car. Had we not filed a complaint with the Agency of Healthcare Administration in Florida, AHCA, there's a good chance Molina Medicaid would not have paid the hospital bill. That would have meant Ray would end up owing $99,000 or so. After we receive the settlement, we take our attorney's fees, and then he would owe that. Now, if Molina Medicaid didn't pay, we could still try to negotiate the hospital a bill down by doing an audit of the bill, hiring a professional to look at it and say, this is the reasonable charge, because hospitals are known for overbilling and charging very high amounts. Just because a hospital charges a high amount doesn't mean the injured person needs to pay back the full balance. Now, CNA's opening offer was $150,000 to settle Ray's personal injury claim. That is his claim for out-of-pocket medical bills, and he lost wages and pain and suffering. I have to give CNA credit. They opened up with the $150,000 first offer. If this case had been with State Farm, Geico, Progressive, or Allstate, the offer would have been a fraction of that. So I have to give credit to CNA. When they made that $150,000 offer, they wanted an affidavit from the Uber driver stating he didn't own a car. In other words, CNA was looking to make sure there was no PIP insurance, because if there was PIP insurance, that would pay his medical bills and chop down the amount of medical bills that would be out of pocket for him. We created that affidavit and sent it to CNA, and that helped us get more money for him. Now, after about 1 month of negotiation, CNA had increased their offer to $200,000. We had decreased our demand, our offer to settle down. And CNA's reasoning for offering $200,000 and not more was that no injuries were complained of at the scene. The MRI did not show swelling, which I already discussed. And Ray did not immediately take an ambulance to the hospital. He waited hours to go to the hospital. Patience is key in these cases. You need to know when to give an insurance company a little bit of time to negotiate to try to get fair value for a case, and when to file a lawsuit. Because negotiations were moving along, and although it did take some time between offers and demands, we got from $150,000 to $200,000 offer in about a month. At that point, the adjuster said she had a little more room to move. Now, a little more room to move, meaning increase her offer, in some cases that can be literally $1,000, and as you'll see in this case, a little more room to move ended up being $60,000. So just because an insurance adjuster for the at-fault party says they have only a little more room can be $60,000. I think everyone would agree $60,000 is a large amount of money. So don't always believe the insurance adjusters what they say. They are trained to be persuasive. They handle hundreds of cases, or about 100 cases or so, plus or minus, at a time. They typically, in cases like this where the case value is $260,000, have years and years and years of experience negotiating. They are very savvy and smooth. This case, in all fairness, the adjuster for CNA was very sweet and nice, although the negotiation process still took about 2 months to get them from $150,000 CNA up to $260,000. One of the best decisions my client did in this case was very shortly after the accident, like I said earlier, about a few hours after the accident, he reached out to myself, an Uber accident lawyer, and asked what his rights are and what he should do. This prevented him from making a mistake and giving a recorded statement to the at-fault driver's insurance company, which could have devalued his case. If the Uber driver did not have an attorney in this case, he wouldn't have known to file a complaint with the Department of Insurance to get the property damage paid for the car that he was driving, to file a complaint with ACA to get his Medicaid to pay the hospital bill, and many, many other things, including negotiation and case value. Now, like I said, we reached out to Molina Medicaid. They've told us that they have paid their portion, what was owed based on the law of the hospital bill. So hopefully the hospital bill should be writing off the balance, which would mean the $99,000 minus what we have to reimburse Molina Medicaid would go to my client. We are following up with the hospital every day to confirm that the balance is zero. The hospital happens to be disorganized, which is frustrating, but patience can be key in these cases. It's important not to rush the settlement. Now, it took 2 months for us to get CNA from $150,000 to $260,000 to settle the case. Had we been desperate, or my client had been desperate to settle, we would not have gotten the $260,000 settlement. I believe the insurance company, CNA, would have sensed the desperation and made a lower offer. The Uber driver right now medically doesn't have any plans to have surgery. Surgery is not recommended. He doesn't even have any plans to follow up with the doctor to treat his back injury, which is great news because he doesn't feel that he needs it. Now, a $260,000 settlement is not the norm for a car accident case without surgery. The reason why the case settled for $260,000, which I've already discussed, is we had a very large medical bill, and the insurance adjuster knows that in Florida, the jury gets to hear the total bill charge if the case goes to trial. So if we present the case to trial, the jury gets to hear that the total bill charges in this case were somewhere around $105,000 or so. That would be the total hospital charge plus the physical therapy charge plus the neurosurgeon's charge and the doctors from the hospital as well. All things equal, the higher total medical bill, the higher amounts that juries award for pain and suffering. If the jury hears a very large number for total medical bills, they're likely to award a larger number for pain and suffering. Surgery typically adds a lot of value to the case. If the Uber driver had had a fusion surgery or some other type of surgery, the settlement would have been a lot more than $260,000. The majority of this settlement was for pain and suffering. About $255,000 or so out of the $260,000 were for pain and suffering. Now, my attorney's fees do come out of the $260,000, but my client was very happy with the result. Now I'm going to turn it over to you. Do you think $260,000 is a good settlement for a car accident where the injured person does not have surgery? Please let me know. Do you think it's a bad settlement? Let me know as well. If you like this video, please like it. Please subscribe to our channel. I am attorney Justin Ziegler with an office in Coral Gables, Miami-Dade County, Florida, serving the entire state of Florida.